High Court this past week. The Supreme Court this week handed down decisions in 4 cases, including United Paperworkers v. Misco, where the justices unanimously decided that only in exceptional cases could federal judges overturn decisions by labor arbitrators on grounds of inconsistency with public policy. In Langley v. Federal Deposit Insurance Corporation, the court issued a highly technical ruling that, according to the New York Times, bolstered the power of federal regulators to collect debts owed to failed banks that are taken over by the government as receiver. In Gwaltney v. Chesapeake Bay Foundation, the court limited the ability of citizens to sue polluters for past violations of the Federal Clean Water Act. And finally, in Karcher v. May, number 85-1551, the court decided not to rule on a New Jersey law regarding a moment of silence in public schools. More on that decision later in our program. The Supreme Court heard oral argument in 12 cases this week. Among them, Ling v. Northwest Indian Cemetery, questioning whether the federal government's planned development of part of the Six Rivers National Forest in California would violate Indians' religious rights. A case out of New York argued Monday was Marino v. Ortiz, in which white police officers challenged their being denied promotion under an affirmative action program that had been taken into court without their participation. Hustler Magazine v. Falwell, number 86-1278, was the focus of the court on Wednesday, in what the New York Times called, quote, the liveliest argument the court has heard in recent memory, end of quote. The subject was to what extent parody and satire are protected by the First Amendment. The players, the Reverend Jerry Falwell, and Hustler Magazine publisher Larry Flynt. Joining us to take a look at the oral argument, Al Kamen, legal correspondent for the Washington Post. You began your article on this case by saying it was theater rarely seen at the Supreme Court. Set the scene for us.
Well, the scene, I have to tell you what usually happens. What usually happens is a few lawyers who are almost by definition dull get in front of the court and talk about dull things, which may or may not have constitutional significance. In this instance, we had 2, for want of a better word, characters, and one an exceptional character in Larry Flynt. We had Larry Flynt in a gold-plated wheelchair, one side of the courtroom. We had Jerry Falwell, the silver-haired, somber minister on the other side, battling over a judgment of $200,000 that Falwell won against Flynt when Falwell proved that Flynt had intentionally inflicted emotional distress on Falwell by publishing a parody of an ad in which he portrayed Falwell as an incestuous drunkard having relations with his mother in an outhouse.
So this case had come up through various courts.
It had come up first through a Roanoke trial. It was a libel trial. Falwell called his lawyer when he saw the ad, and he said, "Get him." Falwell later said it was when he saw that Flynt had accused his mother of being a whore, that he got upset. And Falwell sued Flynt for $45 million for libel. A jury said there was no libel because it was a parody. It was an obvious parody. It was a satire. And they nevertheless gave Falwell $200,000 for infliction of emotional distress, which in shorthand means Flynt made him feel bad. Shouldn't have made him feel bad. We're going to dun Flynt $200,000. Flynt appealed, and the Court of Appeals upheld the jury verdict. What was interesting was both litigants were present at the court. Doesn't often happen. And the last time Flynt was present, he was arrested for screaming obscenities at the justices. So all of us in the press were waiting to see if Flynt was going to behave himself. And he did.
I want to talk a little bit about that, but go back and tell us a little bit about the feeling at the court, the mood at the court before the case came up.
It was showtime. It was star time. I mean, it is simply not often that you have 2 celebrities appearing in front of the court, or at least in the court, watching their case being argued. You had cameras rolling everywhere. You had Flynt and his entourage coming in. You had Falwell and his entourage coming in. And it was probably wise that they were on opposite sides of the courtroom. These 2 men do not like each other. But it had a feeling of almost Hollywood drama, of theater. And it really is a contrast between the very dry and and somber posture that the court is usually in. And also, the justices were fairly funny in their questioning, so that made for a much livelier argument, especially when Scalia asked, well, how would the Founding Fathers have felt about parodies of this nature? And the lawyer for Flynt said, well, they were subjected to terrible cartoons portraying George Washington as an ass. And Scalia said, well, I'm sure George could handle that. I could handle that too. But at least he wasn't being portrayed as, having relations with his mother in an outhouse. The problem with the case was they were trying to draw a line. And it's a difficult line to draw between what is acceptable and what is not acceptable, and how you protect people from a vicious parody, or whether you can, under the First Amendment, protect people from a vicious parody without stepping on people's First Amendment rights.
No cameras in the court, so we have to reenact the oral argument here a little bit. What was the major argument on each side?
Well, the major argument was you have someone who has intentionally set out to harm another person through a vicious attack on, in this instance, the person's mother. And obviously the justices were upset about that. And a lot of the questioning to Flynt's lawyer took that attitude. At one point, Justice Stevens or Justice Scalia said, does that mean that once you enter public life, that's it? You have no protection whatever from the most vicious slanders? And in essence, as the lawyer for Flynt said, yes, as long as there's no accusation that is untruthful, that's the way it's got to be. And he compared what Flynt did to what Gary Trudeau does in Doonesbury, calling George Bush a wimp who mortgaged it, or who put his manhood into a blind trust. That's pretty rough stuff. But if you're going to put fine Larry Flynt $200,000, then George Bush would have the right to sue Gary Trudeau, and Trudeau would have to pay $200,000 or whatever a jury decided. The justices clearly were upset by the parody. I mean, you could see that they did not like Larry Flynt. They had no reason to like Larry Flynt. They remembered the last time Larry Flynt was in the courtroom. And they probably were trying to figure out a way to stop people like Larry Flynt from doing that type of outrageous satire. On the other hand, you could see the other side of the argument was very important to them and bothered them, and that was, where do you draw the line? Because you don't want to stop cartoonists from being able to caricature people. You don't want to stop satirist Mark Russell from being able to poke fun at folks. And all of them together intentionally inflict some form of emotional harm. I mean, they intend to poke fun, which obviously makes the subject feel bad. I mean, maybe if the person's got a good sense of humor, they can laugh it off, but it is still distressing to someone to be the butt of a cartoon.
You mentioned George Bush. Another politician's name came up in that oral argument, Gary Hart.
Well, Gary Hart did. Sandra Day O'Connor, Justice Sandra Day O'Connor, asked Falwell's attorney how this type of caricature, this emotional distress argument, would work with someone like Gary Hart, where the press uncovered his relationship with the model actress Donna Rice. Could Gary Hart, under this standard of emotional distress, sue the press, sue the Miami Herald, because they intentionally sought to expose that relationship, which inflicted emotional distress, if nothing else, on Gary Hart? The answer was, from Falwell's lawyer, no. That's not the same, because what the press was doing was reporting truthful occurrences of a political figure. Falwell, outside the courthouse in a press conference, said the only thing the Miami Herald did wrong in exposing Gary Hart was not to have someone watching the back door at all times in Hart's townhouse. But it's true that virtually every public official of a high rank has been caricatured at one time or another. George Bush, Ronald Reagan, Ed Meese, any cabinet level of Jim Watt was certainly one of the most caricatured. And there always is a possibility that someone will go too far. The problem is where do you draw that line, and do you let cartoonists and satirists know that they can be sued if they go over that very wavy and almost impossible to draw line? And I think that's really the issue that the justices are grappling with.
You mentioned the press conference outside the Supreme Court. Before we take a look at that, you've alluded twice to the story of Larry Flynt before the Supreme Court before this time.
Right.
Tell it to us again. You were there.
Oh, I was there. It was the first story I ever covered at the
What
Supreme
year?
Court. November 1983.
What happened?
It was a libel case. And in fact, in that case, Falwell's current lawyer was representing Penthouse Magazine, Bob Guccione, in a libel suit involving a situation with his now wife and then girlfriend. But the situation was Flynt was sitting in the back of the courthouse. The argument went on. And at the end of the oral argument, just as the justices sat recessed for the next argument, Flynt started screaming some very foul obscenities at the justices.
In the middle of the room? In
the middle of the courtroom with all the justices sitting there. Berger, former Chief Justice Warren Berger, turned several shades of red, then lavender, then green. I mean, it was extraordinary. And he pointed to Flynt and he said, "Marshal, arrest that man." It was an amazing breach of decorum, and probably the first time ever that a litigant, not someone coming in from outside sitting in the audience causing a ruckus, but a litigant in a case had been arrested at the Supreme Court and been hauled off. And the marshals converged on Flynt and grabbed his wheelchair and whisked him away, and he was still screaming obscenities as they wheeled him out. It was truly an extraordinary event.
There was a lot of security around him.
There were, yesterday, there was one marshal right next to him and a marshal two other marshals right around him. They were prepared. Flynt said he had to promise to be good in order to attend the argument. The court says no, he didn't have to promise anything of the kind. I think probably Flynt's lawyer got him to swear that he would not do anything like he did the last time. But it was remarkable.
We're going to show this news conference stakeout, whatever you want to call it. Anything people should watch for as they watch something like this?
Well, I think, these things, oddly enough, these things are generally fairly as dry as the oral arguments inside. I often don't go to the stakeouts outside because people rarely don't do anything but repeat what was said inside. This one is different. The questions are different. The jostling is different. It's as if Sylvester Stallone was facing off with Arnold Schwarzenegger. I mean, this is Hollywood on the front steps of the Supreme Court. It was packed. The questions were, I don't know what parts you're going to show, but the questions were somewhat outrageous. Well, what did he say about your mother? I mean, were you angry? It's just not what's often done. We're usually treated to things like retroactivity of 1984 rulings where a worker is injured on a platform off the, shore of Texas. I mean, it's just totally different in kind and from the types of press conferences that are usually held afterwards. Now, this is theater. I hope you'll have some cuts that show that.
We are going to show the entirety from the time they begin to the time they end. So we'll take a look at that and come back.
We got an engineer who can lower this. Can we lower this? Can you move so we can see? Can one of you guys lower this?
Are you ready?
Go ahead. Go ahead.
Okay.
Why did you run this article? Run this parody?
It's satire that Hustler's been dealing with ever since the magazine originated, and that's one of the reasons for its success, is because of the irreverent, iconoclastic editorial appeal.
What about your statement that you wanted to assassinate his integrity?
When that deposition was given, I was in a federal penitentiary when I didn't think I should be there, and the Ninth Circuit agreed with me. So during that deposition, I answered each question the complete opposite as to what I should have, and I did it intentionally.
Mr. Flynt, can you first of all describe the the parody for us, for those of us who haven't seen it?
The parody is based on a Campari ad where they get a celebrity to put their photograph in the corner and they talk about their first time. And it gives you the impression that they're talking about something with a sexual connotation, but it's really the first time that they have tried drinking Campari. So we had Falwell doing the Campari advertisement, but in a parody form. And we identified at the bottom of the page that it was an ad parody and that it was not to be taken serious. And the jury agreed on that.
And what's he doing in the
because they found no lie. All we said his first time was with his mother in an outhouse. And, you know, he's always sloshed when he goes to the pulpit. You know, I mean, just ridiculous stuff that, you know.
Falwell's lawyers said this is the kind of conduct that, or the kind of behavior that no one should have to put up with. That's basically their argument. What do you say?
One thing to say, and it's the only thing important, despite the arguments that went on today, the basic issue is if that jury's decision is allowed to stand, that means that any journalist or political cartoonist that does an article or a cartoon that is unfavorable to an individual, that person can sue. He doesn't have to prove liable. He can go in the courtroom and say, I know I wasn't liable by this, but it's upset my whole family. I've been seeing a psychiatrist. I haven't been able to sleep. So he is in a position to collect damages on emotional stress. Now, how can a free press function under those kind of conditions? And that's the issue here. And I think that's why the Supreme Court agreed to hear the case, is because they didn't want the Fourth Circuit, you know, setting that kind of precedence without a review.
You seem to be saying the more outrageous something is, the more unbelievable it is, the more immunized the publisher is.
It's magazines like Hustler that need protection of the First Amendment, not the Washington Post. We offend a lot more people than the Washington Post do. But I think that the First Amendment gives me the right to be offensive. And that's what the issue is here. My indictment is basically for bad taste.
Yeah, but the question, what you seem to be saying is the more outrageous, the more unbelievable what you say is, the more protected it is. Because if it's believable, it would be libelous.
Right. Yeah, sure, because he was asked on the witness stand if he took it serious when he read it, if he really thought, you know, that anybody felt that he had sex with his mother or got drunk when he went to the pulpit. Here's my attorney, Alan Isaac.
The more outrageous it is, the more protected it is.
It's not a question of more protected or less protected. It's either protected or it's not protected. If it's believable as a statement of fact, then it may not be protected. If it's not believable as an assertion of fact, then it is protected. I mean, don't you think George? Don't you think George Bush was upset when Doonesbury painted him as a wimp? He said that he was a basket case the rest of the day. Now, he may have suffered serious emotional distress. Is he allowed to come into court? DC Follies every Saturday does a TV show on ABC. Saturday Night Live does a TV show. They have political skits all the time. Are the people in those political skits permitted to come in court and sue for intentional infliction of emotional distress? And the defense that, well, we didn't say anything factual about you, they'll say, we don't care. We don't care whether you say anything factual. You hurt our feelings. You caused this distress. And you can see the extreme that this case went to, because Jerry Falwell, unlike what Larry Flynt just said, didn't even go get a psychiatrist. And he's concerned, as he ought to be, about somebody getting a psychiatrist or a doctor coming in saying all these terrible things. He didn't get a psychiatrist. He didn't miss a day of work. He didn't miss any sleep. He didn't lose any weight.
Mr. Flynt, your opponent in this case said that this is speech that doesn't matter, that it shouldn't be protected because it's speech that doesn't matter.
To live in a free society, you've got to pay a price, and that price is toleration. You have to tolerate things that you don't necessarily like. So The Larry Flints of the world have to be tolerated, and the Falwellians of the world have to be tolerated. And that's what the issue is. My speech is just as important as Jerry Falwell's, probably more so.
Under the circumstances, if the press is going to be saddled with the result of this thing, are you sorry now that you started the whole thing?
Well, I regret that I have brought this issue before the court, and that the national press could be affected by their decision. It makes me feel very badly, and I just hope that don't happen.
Did you think that Jerry Falwell was libel proof when you did the parody?
We knew he was a public figure, so we submitted the ad parody to our legal department. They approved it. I said, note at the bottom that it's an ad parody, not to be taken seriously.
Thank you very much, Mr. Flynt. We appreciate it.
Hey, you mind moving? Come on, everybody in the white. Can this not get lower? Reverend Falwell, one of the questions they raised, several of the justices raised, was, where do you draw the line? How is a columnist or a cartoonist to know how offensive is too offensive?
My wife and I have an album at home. We collect all the cartoons about Jerry Falwell. I've been harpooned by everybody at least once. And we are amused by every one of them, and we gather them as a hobby. I have never in my life been incensed by a single one. I've never been led to believe that any of them were malicious or were designed to inflict emotional injury until in the Washington airport I first saw a pre-publication copy of the Larry Flynt Campari ad, which was handed me by a member of the media. Riding the plane home, I read the ad. I landed in Lynchburg, Virginia, called Roy Grudman and said, get him.
Why did you send 500,000 copies out to your supporters?
He didn't send 500,000 copies out.
How many did you send out?
He sent out expurgated copies in which some of the most offensive things were deleted. Yes, he sent out copies that were edited with some of the most offensive things deleted in order to tell people who might otherwise believe that this was real, that it was not. And it was an appeal for people to support the cause of preventing this kind of funds. Exactly.
Well, how much did this satire hurt you, and how did it hurt you?
It's a question of the person.
Let him answer.
You know, I said that I have never been incensed by a political cartoonist or any other kind of cartoonist other than Mr. Flynt. When he suggested that as a minister of the gospel, that I had been involved incestuously with my late mother, who died at age 82, some years earlier, a godly woman whose memory has never been blemished by anyone. And when he suggested that that my mother was a whore, a prostitute, I can't imagine any red-blooded male in any nation on earth not being incensed by that. And my purpose was twofold. One, to recover damages that I think have been imposed upon myself and my family. But secondly, to bring an end to the kind of sleaze merchantry that Larry Flynt typifies. There are very few like Larry Flynt in the world today. There are a few, but very few like him. And contrary to what we heard on the stand today, I do not put Bob Guccione and Hugh Hefner, with whom I was in some kind of television debate last night, in the same class. I put them in a very low class, but not in the sub-basement.
There's still a question of damages. You say you were incensed. Is there anything beyond? Yeah, sure. Is there anything beyond being incensed? Any demonstrable damage?
Yes, I personally was anguished, am still hurt.
But beyond hurt feelings, is there anything you can point to? You didn't get psychiatric help? You didn't lose time off from work?
Having gone through that in two courts already and having satisfied both courts that we were injured to their satisfaction, I don't think that any further discussion of that is needed.
What beyond hurt feelings is the injury?
May I have your question, please?
Thank you. I was wondering if you could explain to us why it seems here that you had some kind of idea of getting even.
He didn't say that.
You said in an interview that you did for us, you said that I thought that I would just get him because it made me so mad.
I have never in my life said get even. I have said repeatedly he must be stopped. My attorney was charged to go through proper legal channels to bring an end to this kind of unbridled, unbelievably reckless so-called journalism. The First Amendment does not give anyone the right, the liberty, to scream fire in a crowded theater when there is no fire. And I believe that the media likewise has some restrictions, and this is one of them.
Did you think anyone would believe this, or that they would just think it was a parody?
I think that this is as public a forum as one can be involved in, the United States Supreme Court, and I'm hopeful that the justices here will feel as strongly about it as 6 of them did in the Fourth Circuit Court of Appeals.
Is there a personal animosity here?
What's that?
You think there's a personal animosity here between yourself and Mr. Flynt?
None whatsoever. I feel a great deal of sympathy for Mr. Flynt. His wife recently died of AIDS. He is a very lonely person. He's a very sad person. And I personally pray for him. That does not mean that if someone is breaking into my home, that I'm just going to pray for him. I'm also going to stop him while I pray for him.
Reverend, the court was almost asking, virtually begging for someone to tell them where the line was. Who do you go after and who don't you? Can you suggest where that line is?
You can't do that. When the court lays down rules, when the court lays down rules, it lays them down in broad generalities that have applicability to cases that haven't happened. They don't prescribe that you can't do this specifically or not do that specifically. They lay down things, and they do it at some length.
How's an editor to know? How's someone to know what's too offensive?
Editors have known that for hundreds of years. They have known it at least for the 100 years that this tort has existed. And by responsible restraint, by being a member of the community and exercising the same kind of judgment that they do every day of the week in knowing what they can do and what they cannot do, when they decide not to publish the identity of a rape victim in a crime where they haven't yet apprehended the malefactor, that's journalistic restraint. And if they did publish it, guess what? That is the intentional infliction of emotional distress, and a court has so decided.
But this is humor.
That's not, one man's belly laugh is another man's groan, and humor is not a defense. You can't say, well, I thought that this gross attack would be considered funny. In this case, Larry Flynt admitted it wasn't humor, it wasn't parody. He wanted to settle a score, he wanted to assassinate his reputation, he wanted to injure him to the maximum extent possible. Now I ask you, can that be justified as a proper journalistic objection?
It was clearly labeled parody.
Yes. Clearly labeled in minuscule type, it was a fig leaf. Yes.
Falwell, can you tell us whether or not you think the pulpit is strong enough to combat this thing, or did you have to resort to the courts in order to get even? How about your opportunity on television?
Well, first of all, no one representing Jerry Falwell was instructed to get even. I am not a believer in getting even. I do believe that we're a country, a government of laws, and I do believe that everyone is answerable to the law and no one is above the law. Mr. Flynt, in my opinion, has been operating above the law because of the ambiguity of this kind of situation. I feel that we're doing a service to the legitimate media, not a disservice, to help protect the rights of human beings in our society from the likes of Larry Flynt. There's not a person gathered around here, in my opinion, who has any reason to be afraid of a favorable ruling in our favor by this Supreme Court. And there's not a person around here who, in my opinion, would have read an ad in any magazine that depicted you in the same way with your mother as I was depicted, that would not feel, in my opinion, as anguished as I. And I think that it boils down to the fact that responsibility is for everyone, the media included.
Thank you very much.
Thank you.
Yes,
Al Kamen, in your words, high drama that we've just seen here, it's a very serious First Amendment case for a lot of people.
Yes, it is extremely serious for the media. There were a lot of briefs filed by media lawyers, and there were a lot of media lawyers in the courtroom yesterday, from New York, from Washington, from all over. The reason is there's a deep concern that if the court allows someone to recover damages under this somewhat amorphous concept of intentional infliction of emotional distress, that it will open all cartoonists, for sure, all satirists, and maybe even all opinion writers up for similar lawsuits. Even if they don't win, it will simply create a whole new area of potential liability for people who are already being sued as it is. And that there is no way really to draw the line between a truly vicious satire, which this one conceitedly was. I mean, everybody understands that. And something not so vicious, but arguably just as distressing, such as Gary Trudeau's allegations against George Bush's manhood. And that is really what is at stake. The question is, what can you do to protect people from that kind of attack within the confines of the First Amendment without stepping on the First Amendment rights of people to say what they think or to poke fun at the powerful. And that, in essence, was what Flynt was doing. It was an outrageous attempt at poking fun at someone who was a powerful religious and political figure in the country.
A decision in this case, when?
Well, it could be soon, but I have a feeling it's going to be later. I have a feeling by July, but probably not until very close to July, probably not until June. I think they're going to take their time with this one.
I want to touch on one more case before we let you go here. Karcher versus May, which was not a case argued this week, but a case decided on this week.
Well, or not decided.
Or not decided. Well, tell us about it.
Right. Well, it was, the case involved New Jersey's moment of silence statute, which is similar to statutes in about half the states in the country, which required a 1-minute moment of silence in all the public schools for introspection or reflection. And the moment of silence is something of a substitute for the 1 minute of prayer that the court struck down in 1962 and 1963 decisions. A lot of states, half of them, have come up with a moment of silence as a way of, some people would argue, of reintroducing prayer back into the schools. The difference is that a teacher is not leading the students in anything. It's all silent. The court has said that it would be willing to allow bona fide, religiously neutral moments of silence. And our best guess is that the court wanted to deal with this case. They wanted to take it. They wanted to approve a moment of silence that appeared to be neutral in terms of religion. But they perhaps tried too hard and discovered unanimously that the people litigating the case didn't have legal standing to do so, and they dismissed it without a decision. What it means is we simply don't know whether moment of silence statutes are constitutional or what types are constitutional. We were left with nothing.
We wait for another case?
We wait for another case, and there's nothing imminent. There are no cases, as far as I know, out in the circuits that are ready to come up. So we may wait a year or two before we get an answer to the question. In the meantime, people will just have to go along doing what they're doing, whatever that is.
Final question. Now, 2 months into this term, what's your opinion of what's going on at the court this year?
Slow term. Part of the slowness is due to the fact that there are 8 justices. And there are some cases, some important ones, that are quite likely being held for a 9th justice. But on the other hand, the administration, which has been carrying a crusade to the court on its social agenda in recent terms, doesn't have much before the justices this term. We don't have the affirmative action abortion, religion, church-state cases that we have had, or criminal cases that we have had in years past, that have added to the excitement and the drama of what's going on at the court. This term has got, and several of the justices have conceded as much, some dull cases.
Will that change?
Dull cases. Not going to change this term, because the term is almost, the calendar is almost filled up until April. And it doesn't look like there's going to be much change. Even if Kennedy were to join the court in January or February, it's unlikely that this will be seen as a blockbuster term. Much duller than any of the last three, unfortunately.
Al Kamen of the Washington Post, thank you. Next week, the Supreme Court hears oral argument in 12 cases, including one that will take a look at whether alcoholism is a disease for the purpose of providing certain benefits to veterans. The court is expected to decide whether a Veterans Administration regulation that defines alcoholism as willful misconduct discriminates against the handicapped and thus violates the Rehabilitation Act of 1973. The case is brought by Army veterans Eugene Traynor and James McKelvey. This case, the focus of our next Supreme Court review, December 12th. Supreme Court Review is part of C-SPAN's ongoing series, America and the Courts, taking an educational look at the federal judiciary. If you have questions about the Supreme Court, you can write Supreme Court of the United States, Washington, D.C., 20543.
Join C-SPAN as the National Press Club honors